So I'm going to talk to you about the Violence Against Women Act, primarily the 2013 reauthorization. We'll also go through the 2005 reauthorization, where for the first time the housing protections for survivors of domestic violence, dating violence, and stalking showed up in VAWA. And in addition to talking about the Violence Against Women Act, we'll do a quick overview of the federal housing programs, though I think my crew over here probably knows more than most of us in the room. In addition to the Violence Against Women Act, survivors have other protections under state landlord-tenant law, and I think you're going to hear about the Tennessee protections later on today, also state fair housing laws, and of course the Federal Fair Housing Act. There's a terrific 50-state compendium put together by the National Housing Law Project out in California that goes through the various protections for survivors of domestic violence, dating violence, and sexual assault who need housing assistance. For example, in Illinois, where I'm from, we have what's called the Safe Homes Act that allows a survivor of violence to end their lease early if there's a credible imminent threat of harm against them on the premises. We've had that on the books since 2007 and have helped thousands of survivors around the state exit a lease when they are unsafe and access safe housing. So as I said, VAWA 2013 continues the protections that were set forth in VAWA 2005 and also provides new protections. VAWA 2013 provisions are effective for the most part now. There are some parts of VAWA 2013 where in the statute, Congress is saying we need more guidance from HUD and the other federal agencies, Department of Agriculture, Department of Treasury, before we expect housing providers covered by VAWA 2013 to implement those provisions. HUD in August of 2013 sought guidance on some of those provisions, including the new emergency transfer process set forth in VAWA 2013 and a couple other measures I'll talk about. VAWA 2013 also streamlines the housing protections, so they currently are, I should say, in the various parts of the U.S. Housing Act. Now they're going to be codified at 42 U.S.C. Section 41411. So they're all in one place, which is hopefully easier for everyone. HUD issued a final reg on VAWA 2005 in October of 2010. Those regulations continue to apply to the public housing, project-based Section 8 housing, and to the Housing Choice Voucher Program. There's very helpful language for survivors in those regs, and I think helpful guidance for housing providers to understand what their obligations are. So those are, just to be clear, those are in effect until we see an interim rule issued under VAWA 2013. I'm going to go through this. So expanded coverage. Under VAWA 2005, the public housing program, the project-based Section 8 program, and the Housing Choice Voucher Program were covered. By regulation, HUD extended the 2005 protections to the Section 202 and the Section 811 programs. Now, under VAWA 2013, there are 7 additional housing programs covered, including the Section 236 and below market interest rate program, which is one of the older HUD programs where they provided a below market interest rate mortgage to a private owner in exchange for reduced rents to low and moderate income tenants. Those projects were not successful. Financially, they were difficult to manage. So you'll see one of those features typically is they also have some form of project-based subsidy, not typically 100%, but some number of units may have a project-based Section 8 contract attached to them, but they still have the use restriction for those other units. So they're affordable not because of project-based subsidy, but because of the underlying 236 or BMIR use restriction in place at the property. Home properties that are covered by the home program are also now covered by VAWA 2013. The HOPWA program, Housing Opportunity for People with AIDS, is also now covered by VAWA 2013. The McKinney-Vento program is also covered. The Rural Development 515 program is now covered, and the Low-Income Housing Tax Credit program is now covered. I'm going to sort of skip through these. If you have questions about these various housing programs, I'm happy to talk to you individually. There is a preservation database. If you're not sure if the housing is covered by VAWA or the type of housing that it is, you can go to this link, http://preservationdatabase.org, and it will give you the various, it'll look through the various types of federal housing programs. You can search by address, you can search by program type, you can search by name of the property, you can even search by state. So under VAWA 2013, domestic violence, dating violence, stalking continue to be covered. Sexual assault survivors are now covered as well by VAWA 2013. Congress also used a new term, affiliated individual of the victim, which means immediate family or any individual living in the household. This new definition is intended to cover the LGBT community. Admissions. Housing authorities, landlords, and owners shall not deny an applicant housing on the basis that an applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. Evictions and terminations. Housing providers may not deny assistance, terminate assistance, or evict a tenant on the basis that she has been or is a survivor. Crimes against a survivor directly relating to the abuse are not grounds for evicting the survivor or terminating her rental subsidy. HUD has not defined what directly relating to the abuse is, and at this point there's not a lot of case law, but what case law is out there I'll talk about. As well, an incident of actual or threatened domestic violence does not constitute a serious or repeated lease violation or good cause for evicting the survivor or terminating the rental subsidy. This is one of the reported cases under VAWA, Metro North Owners versus Thorpe. Ms. Thorpe was a Section 8 voucher holder. Her ex-boyfriend came to the property, broke into her unit, and injured himself when he was trying to break in. He was caught by a security guard who made a report. Shortly thereafter, she was issued an eviction notice for nuisance due to several domestic disputes between you and John. I've seen this type of notice. I continue to see this type of notice all the time. Ms. Thorpe had several police reports and a restraining order documenting the violence against her by her ex-boyfriend. The court found when the property owner tried to evict Ms. Thorpe and she asserted VAWA as her affirmative defense, the court found that the landlord was prohibited from evicting her under the Violence Against Women Act. What limitations there are. A housing provider can still evict if they can demonstrate an actual and imminent threat to other tenants or employees at the property if the survivor is not evicted. The and is important. It's always been in the statute, actual and imminent threat, since VAWA 2005 came into place in 2006. But the initial HUD regulations switched it to or. And they say that was by accident. But what we saw across the country is that housing providers then incorporated that language into their planning documents and perceived it to be an or. And the final regs for HUD have clarified it, said it was in air, and it is back to being an and most importantly, the statute says and. So it must be an actual and an imminent threat. And then, while it is not defined by VAWA what actual and imminent threat is, the HUD final rule does define it. It says that threat consists of physical danger that is real, that would occur within an immediate time frame, and could result in death or serious bodily injury. Factors to be considered include the duration of the risk, the nature and the severity of the potential harm, the likelihood likelihood that the harm will occur and the length of time before the harm would occur. HUD also admonishes housing providers that eviction should only occur if no other action can be taken that would reduce or eliminate the threat to other tenants or employees at the property. Some of the suggestions that HUD provides: evict the perpetrator only, institute a bar order against the perpetrator, get the police involved in keeping the perpetrator away from the property, provide support and domestic violence services to the survivor, transfer the survivor to other housing. So HUD is saying, do everything in your power to ensure the tenant's safety before you would take action to evict them because they are in fact a victim of domestic violence. Removing the abuser from the unit. A housing authority or Section 8 landlord may also bifurcate the lease to evict a tenant who commits domestic violence while preserving the tenancy rights. This is a way to remove the abuser from the home. It is, however, subject to state or local law. At this point, HUD is saying, and Congress is saying, they are not preempting state or local law. And so there isn't specific guidance on how this can be implemented. In Illinois, in response to what we saw in VAWA and to other needs of other survivors in private market rental housing, we passed a law that provides the right of a property owner to evict the perpetrator only, since it was unclear in our state eviction laws if you could evict one person from a home as opposed to the entire household. What I have seen prior to passage of that and in other states is housing providers will transfer the survivor out of the unit and then initiate a termination proceeding against the perpetrator. And it is important to first ensure that the survivor is safe before you take independent action against the perpetrator, because you may unintentionally escalate the situation, right? If you are initiating a termination proceeding against the perpetrator only while the survivor's in the home. There's also under VAWA 2013 a new protection for tenants remaining in housing as a result of a lease bifurcation. If the individual who's evicted was the sole tenant eligible to receive the housing assistance, that remaining person has an opportunity to establish that they are eligible for the housing that they're in, or that they are eligible for any other covered housing program. So any of the 12 that they could say, I may not be eligible for public housing, but I am eligible for something else. I'm eligible for the tax credit program, for example. And they would have time then to move to that new program. This is one of the areas where we still need HUD guidance. It is not clear how much time should the remaining tenant be given to establish that they are eligible for the housing. How much time would they be given to move out of the unit if they're not eligible for any housing? Let's say that they are undocumented, for example, so they wouldn't be eligible. How much time would they have to move without facing an eviction from the housing provider? Or how much time would they have to establish eligibility for another housing program? So this was part of that August 2013 notice I talked about from HUD. HUD was saying to advocates and providers, how much time should we give? And at this point, we don't have HUD's determination of that issue. A housing authority may terminate the Section 8 assistance to the abuser while preserving the assistance to the survivor. In the situation of a family breakup, and this is specific to the voucher program, the PHA must ensure that the victim retains the assistance. One note for advocates, it's helpful to housing authorities if you're able to get the voucher assigned to the survivor as part of a court process with a protective order, restraining order, in a divorce or a separation proceeding. In VAWA, it's been in there since VAWA 2005, they say that a PHA must honor all court orders, and so it's further bolstered by that. Voucher portability. So this is when you have a family with a housing choice voucher and they are unsafe and they flee the unit before talking to the housing provider. And historically, pre-VAWA 2005, this would be a program violation, that they moved in the middle of their lease without permission from the PHA or their property owner. VAWA 2005 creates an exception, says if they move out in violation of their lease, while they typically would have grounds to terminate the subsidy, if they are moving out because of a reasonable and imminent threat and they were moving to maintain their safety, as long as they are in compliance with all other program obligations, the housing authority can continue to provide voucher assistance to that household. As well, typically within a PHA plan, you can prohibit a Section 8 voucher holder from moving during the first term of their lease with a voucher, or moving more than once in a 12-month period. Under the HUD final rule, HUD clarified that those policies cannot be applied to survivors of violence, since the issue there is that they are moving for safety reasons. Emergency transfers. This is one of the big new provisions under VAWA 2013. This is as well a provision where we are waiting for HUD to issue guidance. And we're also looking to the Department of Treasury for the tax credit program and the Department of Agriculture for the Rural Development Program to issue guidance. This would allow a survivor living in any form of assisted housing covered under VAWA to move to any other form of covered housing in order to protect their safety. And it was written this way because we realized, especially in rural parts of the United States, there may be one public housing development, right? And it's on 2 blocks, and you would move her from one floor to the next, and it would not make a bit of difference. And so we wanted to ensure that we could maximize the extent to which a survivor could be safe and maintain their subsidy. And the only way to do that was to set up a structure where they could move to other covered housing programs and as well potentially access a housing choice voucher. So VAWA 2013 mandates that each federal agency adopt a model emergency transfer plan to be used by project owners and housing authorities. The transfer plan must allow survivors to transfer to another available and safe unit assisted under a covered housing program. The tenant must initiate the request. The request must be in writing. The tenant must reasonably believe that she's threatened with imminent harm from further violence if she remains in the unit, or that there was a sexual assault that occurred on the premises within 90 days of the request. The transfer plan must ensure the survivor's confidentiality so that the housing provider does not disclose the location of the unit to the abuser. HUD must establish procedures under which a survivor requesting an emergency transfer could receive a tenant protection voucher. In the Obama budget, there were 5,000 VAWA vouchers proposed to be allocated. That's not enough, but that's a good start. We're talking to HUD, we're talking to members of Congress about this issue, and again, we're saying the priority should be for these vouchers, since I think sort of putting aside resources, like if we could do that, just put aside resources for a second, the easiest thing for a survivor to make them safe and to keep their subsidy would be to be able to hand out vouchers, right? It would be the easiest thing to do, instead of calling around and trying to find site-based affordable housing that may be in the area that's safe for them. Unfortunately, we know there will never be enough vouchers for that to be possible for everyone. So we have to prioritize who would get them. And at this point, the conversations are really about can we ensure, again, for those individuals who are living in communities where there are so few housing resources, that should be the population that we're prioritizing for the vouchers. For larger PHAs, like in my town and at the Chicago Housing Authority, we also think that they have vouchers that they can utilize on their own without tapping into this tenant protection voucher pool. That's not the case for most other PHAs, but for the CHA it is. So implementation issues, this is an emergency need. I had an email just last night from an advocate in downstate Illinois asking what can be done to transfer a client prior to the HUD rules coming out on the transfer process. HUD has made clear to PHAs in particular, nothing prevents you from still transferring survivors now. This should be a permissive transfer that you can make and can make on an emergency basis. As well, Chapter 19 of the Public Housing Occupancy Guidebook talks about implementing an emergency transfer process. We did this several years ago with the Chicago Housing Authority. We were finding that it was taking months, if not more than a year, for a survivor to make a transfer request and have that transfer request granted. And horrible things were happening while they were waiting, including a client that was shot by her abuser. So the CHA saw this as an issue for their client population and worked with us to establish it. And we have about a 48 to 72 hour turnaround now on moving survivors to other units. Again, I appreciate the scale of the Chicago Housing Authority is different from most providers. And so you have to work with your housing providers, hear what their limitations are, and try to develop a response that works. We also developed a transfer program through our multifamily project-based Section 8 programs in Chicago, where we are dealing with an owner that's got 100 units on this block, and that's it. And so with the HUD multifamily office, they established a pilot program. They told all their project owners, we are encouraging you to adopt an admission preference for victims of violence. And if you do that, we will help transfer survivors across the various projects in the city of Chicago. Doesn't have to be the same owner, doesn't have to be the same manager. So we have a point person at our HUD office. We call them, we provide documentation of the violence, and they are moved within typically a week to sometimes 2 weeks. It makes a big difference. It really helps survivors when you're able to tell them, I will be able to keep your affordable housing and you can be safe. VAWA proof requirements. Let's assume that a housing authority or a project owner seeks to evict because of a lease violation. The tenant is saying that the violation is related to the domestic violence. A housing authority or project owner is free to take the tenant at their word. So a tenant comes in, and I've talked to housing providers, they say a tenant comes in and I know she's been a victim of domestic violence. We've all known, we've seen it. We've seen what has happened. We've seen the bruises on her face. You are perfectly fine under VAWA taking their word for it. HUD then does ask that you document it in the client file to show that this is what they did. I observed this and this is what they told me. You can also ask the tenant to prove that they are a victim of violence. Any request, however, must be in writing and give the tenant 14 business days to provide the proof. You can also grant them any extension that they request. Here are the types of proof. First, there's the self-certification form. There are certification forms based on the type of housing. And so at this point, we have for PIH, so this covers the public housing program and the housing choice voucher program, HUD form 50066. This is the only form that is current with VAWA 2013. And so this is the form for public housing and the voucher program. This is current with VAWA 2013, and I'll talk about some of the problems with using the older forms and what can be done. So a PHA owner can request this certification form. The form will state that the applicant or the tenant is a victim of violence, state that the incident is the ground for protection meeting the requirements under VAWA, and include the perpetrator's name, if known and safe to provide. That last provision, if known and safe to provide, is new. It came from VAWA 2013. Only HUD Form 50066 includes that qualifying language about the perpetrator. The older form, HUD Form 91066 for the project-based Section 8 program, does not include that language, but the law is the law. That is the right of survivors. So what do you do as an advocate where you have a client who's been denied admission to the project-based Section 8 program and you're going to use the HUD form? Write it in. Write it in. HUD should have had it done. They don't have it done, so that's what I'm doing. I'm handwriting it in. I'm actually even working with providers to help update their forms. So be a resource so that people are getting the right information and are not providing a perpetrator name if it's not safe to provide. We have had it where it's a security guard at the property where they were, in a relationship and then it became abusive. So it would absolutely not be safe to provide in that type of circumstance. They can also provide a police court or administrative record. The record could be from a federal, state, tribal, territorial, or local entity or an administrative record, or a statement from a third party, which can be from a victim service provider, medical professional, mental health professional, or attorney. The latter two, mental health professional or attorney, are also new and part of VAWA 2013. Now this was a question asked yesterday, a good question about, can it be from any attorney, any victim service provider? No, it says from whom the victim is receiving assistance. So you have to have some relationship with the survivor. They must be signed by both the third party and the survivor under penalty of perjury. Quick quiz, didn't know it, hope you've had your coffee. Can a housing provider require a tenant to provide third-party proof of violence in order to use VAWA's housing protections? No. This is one of the most common mistakes I see everyone make. Advocates, housing providers, I see everyone make, that they assume that you can demand third-party proof. You can accept the tenant's oral representation that they are a victim and you can document it in the file. You can ask that they complete the HUD certification form, but you cannot demand third-party proof. I think the easiest thing to do for everyone involved is to use the HUD certification form. It provides consistent information. There's a narrative provision where the survivor can document their experience and why they're a victim. HUD has stated that an individual requesting protection cannot be required to provide third-party documentation. However, in cases where there are two household members claiming to be the victim and they name each other as the perpetrator, a housing provider can require third-party documentation in that instance. So this came out of the HUD final rule in October of 2010 that HUD said this by regulation, and then now it is part of the statute. So where you have those conflicting certifications, you can ask for that third-party documentation. Can a housing provider deny a request for VAWA protection if the victim has third-party verification from a mental health provider or attorney? No. But if you're writing that letter as the attorney or as the social worker, you should expressly state you are not waiving your privilege, just so that's clear. In Illinois, we have a law that says that it's clear. I think that is unique, however, to Illinois. Under VAWA 2013, Congress put the burden on HUD to develop the notices under VAWA. Prior to that, it was the PHA and the project owners that were required to develop notices and provide them to survivors. So HUD must develop a notice about housing rights for applicants and tenants. HUD has not done that. We hope that that will be coming out soon. We've been told for about a year, next month, in the new year. So if you have any poll, let me know. PHA's owners and managers must provide the HUD notice along with an agency-approved, the self-certification form we talked about, to applicants and to tenants at 3 critical junctures: at the time the applicant is denied residency, at the time the individual is admitted to the housing, and with any notice of eviction or termination of assistance. HUD guidance prohibiting discrimination against persons with limited English proficiency is applicable here, including specifically to the HUD notice. So we have heard that the HUD notice will be coming out in at least 5 additional languages. Implementation issues. What are PHAs, project owners, managers, and advocates to do before HUD develops the notice? I would say this: working together with housing providers and advocates to develop good information about VAWA 2013 and ensuring that that information gets to applicants and tenants in HUD-assisted housing is a great start, and it's not prohibited by VAWA. Really, it's encouraged. And so this should be a team effort to make sure people have the best information possible about their rights under the Violence Against Women Act. PHAs and project owners and managers must comply with current regulations and use the HUD-required lease addendum and lease. At this point, we also do not have a VAWA 2013 lease or lease addendum. That also was supposed to come out in January. It hasn't come out yet. Notice to tenants and other covered housing programs. So we don't have information at this point going out to the tax credit program, to the McKinney-Vento programs, all those additional programs now covered under VAWA 2013. But those providers have been reaching out and asking what information they can provide. Again, it's a great chance to collaborate and work together towards protecting survivor rights. Confidentiality. Information provided by a survivor must be maintained as confidential and cannot be entered into any shared databases. Information that a survivor provides can only be used for purposes of evaluating their rights under the Violence Against Women Act. The exceptions to that are in an eviction proceeding, of course, where VAWA comes up potentially, by court order, or expressly requested by the tenant who's claiming to be the VAWA survivor in writing. It's critical that housing providers establish protocol here. We've seen a lot of gaps with this in particular. People hear things, they see it happening, they may be aware that a particular tenant is a victim of domestic violence, and you really need from the top to have a policy maintaining confidentiality. What we've advised public housing authorities to do is to keep this information with their general counsel, to keep it under lock and key and to be serious about that, and to have a note in the client file that they have to go to the general counsel if there's a question raised about a particular tenant. We did have an incident recently with a survivor of sexual assault where there was a pending criminal case, and the perpetrator's criminal defense attorney called the property manager at a project-based Section 8 development and said, "Tell me everything you know about this woman." And the manager did. Gave him an earful and said, "I don't believe her, I think she's faking it," and went on and on and on. Very clear violation of VAWA, and this would be someone who would be able to potentially file an affirmative suit for violation of VAWA, since those provisions, those confidentiality provisions under the Violence Against Women Act have what I would consider sufficient rights-creating language to allow her to file an affirmative suit. PHA annual plans. The PHA plan must include a statement of any domestic violence programs that the PHA provides, and the 5-year plans must describe goals, objectives, policies, or programs they use to serve survivors' housing needs. There's no preemption for state or local laws that provide greater protections to survivors. What VAWA does not clearly address: cases where the link between domestic violence and the program violation is indirect, such as the abuser refusing to pay rent. Cases where the survivor signed an agreement to keep the abuser off the premises, or to repay damages caused by the abuser. Cases where the survivor is repeatedly reconciling with the abuser. There's also a question of where to file complaints. So there is not express private right of action language under the Violence Against Women Act. We had pushed for that language as part of VAWA 2013. We'd also pushed potentially for the HUD Office of Fair Housing and Equal Opportunity to take complaints, since there's such a connection between VAWA violations and Fair Housing Act violations. That did not move forward. HUD assures us that they have the capacity to take administrative complaints. So you could file, potentially, an administrative complaint, essentially a letter, with your PIH office, your multifamily office, with the Department of Treasury, depending on the particular circumstance. But there isn't anything that's really describing what happens as a result of that process. Whether you could file affirmative litigation in federal court for a violation of VAWA really depends on the provision you believe has been violated. And you have to read that provision to determine if it is focused on the tenant and what rights that tenant has. And then if that would meet the standard for creating that sort of sufficient nexus of rights creating language that would allow your claim to survive. In addition to advocating for individual survivors, consider outreach and training to housing authorities and VAWA 2013, reviewing the policies of housing authorities and owners and suggesting ways that they could improve their policies for survivors, forming a local working group composed of organizations such as housing providers and social workers and legal aid offices to address survivor housing needs. Again, my experience was very positive, that we reached out to our housing authorities. We said, we think you're exposed here because you haven't completely come into compliance with VAWA. We also really want to start this conversation with VAWA as the floor. Let's comply with federal law. Let's get you in good footing there. But really, let's talk about building programs to help survivors. And they took us up on that offer, and we had domestic violence experts that were there to really talk through the various scenarios. So if you look at the Chicago Housing Authority's ACOP, for example, you will see language in there that is not in VAWA, that they put in to really ensure that people could escape violence and maintain their subsidy. I have an article about it. It's free. It's up on our website, where you can look for more information about that. Here's my contact information. I'm happy to take questions now because of this switch up and not going to Knoxville tomorrow. I'm going to be actually getting on a flight relatively soon. So if you have any questions, I'm happy to answer them. They are covered. They are covered. There's no exception in terms of they're reconciling with the abuser, right? Right, right. And this is where having your coalition with domestic violence experts and providing support services, that sort of thing, can go a long way in helping that survivor. You would be able to evaluate if this would meet the actual and imminent threat exception. But remember, that exception is not that the tenant continues to be victimized. It's that that perpetrator is posing a harm to other tenants at the property or to on-site property management staff. But VAWA doesn't otherwise give an exception in terms of someone where they're repeating this cycle of violence. Absolutely, absolutely. So nothing is protecting the perpetrator here. This is to protect the housing rights of the survivor of violence. But you absolutely have your existing rights for criminal activity to evict the abuser. And you look to the VAWA language too. They're talking about taking action to remove that abuser from the subsidy, from the home, terminating their assistance. Yes, yes. So private market that doesn't have a Section 8 voucher will not be covered. But you should. The next presentation will talk about what Fair Housing Act protections there may be, or other civil rights protections. There are some states, including Illinois, that specifically also protect any survivor in any type of rental housing from being evicted under our forcible entry and detainer laws. So you have to look to, I'm not sure what your state eviction statute, if there would be a protection there, but I think you'll hear more about the Fair Housing Act protection. So at the beginning I talked about that database. So you look at that database, you can search by address, name of the property, by state, and it'll tell you the type of federal housing program that property is in. And then you can look and see if it's covered by one of the 12 now covered under VAWA. So this is the homeless program, and so you'll see this typically with the supportive housing program, that they'll have McKinney-Vento funds as part of it. There's typically as well some sort of project-based subsidy in there, because the McKinney-Vento itself is not deep enough of a subsidy. So that's typically where I see it. It could also be covering transitional housing programs would be under McKinney-Vento. So that's where you would typically see it. So there is not express private right of action language under VAWA. But if you look at the provisions that talk about the tenant shall, this sort of thing. The landlord shall not terminate the assistance of the tenant. That type of language under the case law should create a private right of action. Where they're talking about language that says the landlord shall adopt the VAWA lease addendum, there's language like that. We don't believe, looking at the case law, that that creates a private right of action for the tenant because of the focus on the landlord and the lease. The tenant may have other claims outside of VAWA, but may not be able to enforce it through VAWA. So you need to really be going through each section to determine if there's a potential claim. And remember, if this is an eviction case, right, you use this then as your affirmative defense. This is your affirmative defense that you use in the eviction proceedings. If you want to talk further about the sort of rights provisions, I'm happy to do that online. It really is specific to the various provisions. Nothing prevents you from reaching out to this tenant directly and offering assistance and making clear to them that they understand their rights under the Violence Against Women Act, so that this is protected. You know, they may be recanting for a number of reasons, including a perception that they may think that this would jeopardize their housing. So, or it may be part of the cycle of violence. So nothing prevents the housing agency from coming forward and trying to assist that tenant directly and connecting them with an advocate to assist them with the ongoing situation. Nothing prevents the housing provider from instituting, for example, a bar order, right? I mean, that depends on your state law. In Illinois, you have to send a notice that you're barring someone from the property, and then only then can they be arrested for criminal trespass. It gets sticky, though, when the bar orders are instituted, and then those bar orders are applied against the survivor, because then the survivor rarely has, or does not really ever have, control. So, they are not in a position to grant access or deny access to the property. And so the housing authority has to, if it's a housing authority, has to use that, right, to keep the perpetrator off the property and to have the authority to potentially have him arrested for criminal trespass, but not as a basis to terminate the assistance of the survivor. Again, if you look at the research, she doesn't have control. She doesn't have control. And in fact, in our statute in Illinois, we made that clear, that they could never consent. Just so we just sort of took it off the table on a trespass order, that they could never be in a position to consent to entry. Right. And this is, again, why the collaboration with domestic violence advocates is critical, so that there's a conversation about how you do that. But yes, in terms of notifying tenants of their rights under VAWA, that should be happening now. Under VAWA 2005, the onus was on housing providers not just to give the information out to tenants, but to create it. It's just been shifted under VAWA 2013 that now HUD must create the notice, which the providers then are supposed to transmit. But in that interim, before HUD issues the notice, you're to be giving that information out. And I've talked to many, many, many tenants who really do not know about their rights under the Violence Against Women Act and perceive that the rule of any criminal activity on the property applies to them no matter what. Because, right, other provisions do apply. If they're an innocent tenant and there's drug-related criminal activity, that's not necessarily a defense to a termination proceeding. And so they don't see the distinction between the two. But again, this is where having that dialogue and collaboration with domestic violence advocates is so critical, so that you understand how to step into that conversation safely, prioritizing the safety of the survivor, and helping remove them from a dangerous situation. So this is the new provision of VAWA. If the perpetrator was the sole tenant eligible, right, the victim now has time to establish their own eligibility for the program. So they can establish it for the voucher program or for another covered housing program, or let's say they're undocumented, right? Then it may be that they would be given time to move without the threat of an eviction action. And this is where we're waiting for guidance from HUD on how much time they will get to get through all the various hurdles. Because I think the most complicated is, I'm not eligible for this program, but I may be eligible for the others. I mean, who are we going to call? So, so we have to figure out a process that is workable so that you can potentially gain admission to the other programs. For the tax credit program, my understanding is you still have to have some form of legal status. I don't think there's an exception for the tax credit program. Well, I mean, I think that I think you don't want to, set up a false situation, and so I think you have to determine if they are eligible for that voucher and have that voucher, say that that voucher is their sole possession as part of the protective order, for example. I think where they're part of the household, they've done the background check, they've done the recert process, I think then it's a sort of easier request to the court that survivor be awarded the voucher. And then the PHA is obligated to comply with that court order. Right, and she may not be able to get him to leave. I mean, I had a situation where, same thing, he's not on the lease, he was living there, but he had made clear to my client, if you report me or call the police, I'll kill our child. So she was in this home, she was absolutely trapped. From the project owner perspective, it didn't look like she was trapped, because he said, I saw her go to work. You know, she's going to work. I said, of course she's going to work, and she's coming back to the property because she's got to keep her daughter alive. So she's going to do exactly what he tells her to do. And so this is, again, where getting an advocate involved to talk through that situation before even approaching the tenant, because you want to be able to do it in a way that is safe. So, going into the home and trying to talk to her where the abuser may be present may only escalate the violence. I mean, referring here, do you have a domestic violence hotline in Tennessee? You have an advocacy program for domestic violence. Getting those numbers in place for her, that should be the focal point of your conversation. Can you bar him from the property? If you can do that via your state and local law, you can bar him from the property. And then also talking about, is there a way to transfer her? If he doesn't know where she lives, him coming back to the property is only going to be a criminal trespass order or criminal trespass complaint for him, right? But if she's moved somewhere else where he can't get access to her, then he may not be coming back to the property for a number of reasons. And you may be the reason she's able to escape this domestic violence relationship. So, think about those options, about how quickly you could move that individual to secure their safety and give them a fresh start. Even we've had it where we're not able to find a quick transfer, that we work with a domestic violence program, we get them into a domestic violence shelter until the housing provider is able to come up with something else. We've also had it where the HUD office has permitted that the housing provider move them to private market housing and advance the subsidy payment so that they're safe first, and then we'll figure out the long-term solution second. So talk to your HUD office, talk to your domestic violence advocates. Look, these situations are a hot mess. They are sticky, and you need to just keep focusing, what can I do to ensure that the survivor is safe and that they retain their subsidy? They are difficult. These are complicated situations. They don't come in perfectly tied up in a bow where the survivor says, I have my plenary order of protection. I'm getting out of this relationship. I want you to help assist me. It just doesn't happen that way. And so you have to figure out what I can do to prioritize safety and subsidy for the survivor. But that's where this relationship with the domestic violence advocacy community is so critical. No. I mean, it's possible that the transfer protocol that HUD will develop, right, will allow you to keep a couple of units vacant and not count it as a vacant unit, right, and get the full payment. I've heard that as a potential, that they would say there would be a set aside, you would get a full payment, so no penalty to the housing provider for having a vacant unit, not counted against you at all. And these set-aside units would be ones where survivors would shift. But let's be frank, the easiest way to do this is if we had vouchers that you could hand out, right? Because then they could across the country if that's what they needed to be safe. But we don't have that. So other sort of short-term solutions are, if they have to leave the unit because they're unsafe and the housing provider doesn't have anything to offer at the immediate, that they are able to move to a shelter or to the private market without being told you've abandoned your unit, you've abandoned your subsidy, and the housing provider working with the HUD office to see if they can transfer a payment. But this is why these communications need to happen, because Congress isn't going to fix this, right? We're going to be lucky if we keep the 5,000 tenant protection vouchers. We'll be really lucky. So Congress isn't going to fix this. This is a very local issue where you need to think creatively about what can be done. You know, some domestic violence agencies will have units available in the private market where they pay the rent directly to the property owner. So there may be a resource there in terms of moving survivors. It's also that domestic violence advocates really need to be aware of the housing that their clients are living in. I see this all the time, where they are not asking at intake, did you leave a public housing unit? Do you know what type of unit you left? Do you have a voucher? And so the survivor's leaving, they're going into the shelter, they're in there for 45 days. Under the PHA plan, they've abandoned the unit. They have permanently lost, on a practical level, their subsidy. So the domestic violence advocacy community really needs to know the type of housing, to know, are you covered by VAWA? Should we be having a conversation with the housing provider so that we can talk about, again, safety and subsidy? We've done that. We've done that. We've had it where they'll move the survivor and her kids to a hotel for a couple of days until we can figure out our next plan. And so we've sort of patched it together until we can get to that. We've used, if you have homeless prevention funds in your state, we've used homeless prevention funds, to pay for the hotel, to use as a new security deposit if they're able to use a voucher, that sort of thing. That's actually a really good question. There's been this issue about whether this is covered by the Uniform Relocation Act, right? If this type of transfer. This is resident initiated. And so our understanding is HUD will say this is not covered by the Uniform Relocation Act. The resident is going to have to pay the cost of moving. So that's something that advocates need to think about too. There's a cost associated with this that has to be anticipated up front, because absolutely you will have clients that say, I don't have a dime to my name. He took all my money. Get her card. Don't get mine. Everybody go to her. That's great. Thank you. I think it's actually born out of the research in terms of domestic violence survivors about what level of consent they do and do not have. I think there's very little case law under the FHA, which you'll hear about in a minute, and so that is a challenge. But there's at least one case, that's in the Fair Housing Act that I think Tracy's going to talk about it in a bit, where this issue of consent and so-called or perceived reconciliation came up, and the court talked about the battered women syndrome. I think it's Booley, but Tracy will talk about that case, and we'll rate. I think encouraging a victim to reach out for services and connecting them in a very formal way with those services is a good idea. Where I draw the line is on mandating it. And so where a housing provider is saying, you must call the police every time he shows up or you will be evicted. You must call this domestic violence advocate or you will be evicted. You must get an order of protection or you will be evicted. I think doing more to build a relationship, yes. I think making a mandate on some of these, which I have seen providers do, is problematic. Because there's so much that goes into when they're going to call and why. And so it is about building the relationship. And again, if it's getting to the point where the perpetrator, they've taken all these other steps, they've engaged law enforcement, they've reached out to domestic violence advocates, they've tried the transfer, and he's found her and she's reconciling, he's threatening and meeting those actual and imminent threat terms under VAWA, other tenants or staff, on-site staff, then the housing provider can use that provision. I think, again, where I would draw the line is if you're mandating services, calls the police, court orders, it's not consistent with VAWA, and it will really undercut the ability of the survivor to get the services they need. I should probably, do I have a hook? Well, thank you so much. I really appreciate your time.